you.
Thank you for joining us.
It's a pleasure to be here.
Thank you. So my first question is that, well, more and more students, both in the undergraduate and the postgraduate body at Harvard, are interested in antitrust. So naturally enough, they're interested in you. So I was wondering if you could tell me a bit about yourself. How did you get into the antitrust field?
Good question. So I'm an economist, a PhD economist. I've been out of grad school now for 30 years. And my dissertation research and my master's level research was all based on really important questions in the 1980s surrounding the energy markets, the development of global trading patterns in energy, but also domestic competition issues that we were dealing with in natural gas and electricity and the like. So when I left graduate school, I came to Washington, D.C. and worked in private consulting and immediately jumped into looking at competition issues involving antitrust and also regulation. And we know that antitrust and regulation are sort of complements to each other in promoting competition and consumer welfare in markets. After that, I enjoyed it so much, I went to the government to be a federal regulator, also dealing with competition issues. I headed up the merger practice at the Federal Energy Regulatory Commission, and then was really interested in doing even more, and then went out into the nonprofit sector. So it is a fascinating field. It is a field where economists can find versatility and creativity and innovation in how they apply their skills and their knowledge. And we certainly are seeing greater interest in antitrust and competition problems in our economy today.
And just a quick follow-up question. From when you first entered into the field to present day, how has it changed?
Well, it has changed a lot. The last 30 years of antitrust has really been captured by an ideology, if you will, which really favors deference to claimed deficiencies involving mergers and also in conduct in the markets. That has largely been driven by some legal economic doctrine, which we now know and have known for some time to be really inaccurate, and has really done a great disservice to our markets, our economy, our underlying democratic values, in that we've seen tremendous amounts of consolidation over the last 30 years. We're now dealing with sectors with very tight oligopolies and some dominant firms. So now we have many, many problems to address.
Just prior to this interview, we were discussing the small business search engine, Kafia, that Children for America is working on. I'd like to ask a question on exclusionary conduct, and it's a little long-winded, but there's a question at the end, I promise.
Sure.
And it was a concept that appeared in the Verizon versus Trinco case, and may theoretically arise from a Kafia versus Google case. Should Google begin to see the small business engine as a serious competitor and theoretically may attempt to slow down or advertise its products on the website? So my question is, what concerns or lessons do you have surrounding the outcome of the Verizon versus Trinco case? And is there more to be done in terms of preventing exclusionary conduct, something that Kafia would be tending towards?
Good question. So the whole concept of exclusionary conduct, meaning a powerful firm that has market power, the ability to affect prices or to exclude their rivals, using or leveraging or maintaining that market power to really shape competition in the market, is really a concern. And it's become more of a concern given higher levels of consolidation and concentration in key markets. So it's an incredibly important issue. And it really, if you float back up to the 10,000 foot level, Trinco and other cases, Microsoft, for example, 20 years ago, it's all about access. It's all about the ability of smaller rivals, smaller innovative competitors that spring from these entrepreneurial models to gain access to important inputs, critical inputs, but also to distribution. And in the case of Trinco, you have a network, right, a local area network, and the whole premise was smaller rivals trying to get access, to give consumers choice, trying to get access to the network. We see that with the techs now. the big tech platforms, the market online exchanges, where third parties are hosted on the platforms, but they're also competing with the techs themselves, whether it's in search or whether it's in online retailing. So the whole problem of access to these platforms or networks, whether they be traditional railroads or electricity networks, or whether they be tech platforms, and we're really just trying to get access to the technologies that form the platform and the connectivity through the ecosystems that the techs have, that is a really critical issue. And unfortunately, it is not an area of antitrust enforcement that we see much activity in. In fact, we haven't seen a monopolization case, which is where exclusionary conduct would fit. We have not seen many monopolization cases in the last 20 years. And we are pushing very hard for enforcers to, state and federal and private enforcers, to really take a very hard look at how small businesses are being excluded from the markets.
My next question surrounds banking consolidation, which has caused dramatic decline in small business lending over the last 30 years. And we know it's regulated by the Federal Reserve and not by the DOJ or the FTC. Could you tell us any concerns that you have regarding banking consolidation, and why the fintech industry is struggling to offer small business loans?
So banking is one of the sectors where antitrust review of consolidation, review of exclusionary conduct potentially is not is really resides with the federal regulator, the Fed. So the Federal Trade Commission and the U.S. Department of Justice Antitrust Division do not have purview. I believe they can offer comment on these mergers, and there is some collaboration or effort to collaborate, much like we see in some airline matters involving airline competition and the international alliances. That is unfortunate in that having just a sector regulator in charge of competition, overseeing competitive issues, I think is at this point inadequate, because we have had a tremendous amount of banking mergers go through. And that really does affect smaller communities where smaller banks might be swept up in these consolidations, and there is a distinct lack of choice. There are price effects in terms of interest rates, and a lack of competition on offering new products and services, a loss of innovation. So different regions of the area in banking consolidation absolutely are affected severely in many cases. And our organization and others have advocated very strongly for more review, more scrutiny of these transactions, because it does have so many pervasive effects throughout the economy. So, given the market barriers to entry that we're seeing in many industries, because of just a few firms in a market, or a single firm in a market, we are seeing more difficulty in gaining access, smaller firms gaining access to markets. And so that will affect financing for those firms, unfortunately.
So my next question is very much surrounding a conversation that's happening at Harvard at the moment, at the law school. A recent article in the Harvard Law Review by Professor Alhausch talked about how horizontal shareholdings are omnipresent, and his empirical work found that they have adverse economic effects. Mm-hmm. And we know that anti-competitive behavior under these horizontal shareholdings are illegal under current antitrust law. Mm-hmm. Could you tell us your thoughts and potential reasons surrounding the lack of enforcement of this particular law?
Mm-hmm. Good question. So the whole question of horizontal shareholding fits within a bigger set of concerns involving antitrust, where firms own partial shares of each other or in rivals. So there's really two categories. One is common ownership, which is what this article is about. That would be, for example, an investment company owning small shares of rival companies. So take airlines, for example. Well, the concern is if a single company owns a little piece of a bunch of rivals, that would soften or dampen incentives to compete. Why? Because there is a common ownership interest in all of those rivals. If you flip it over, we also have concerns about what we call partial ownership shares, which is rivals owning small parts of other rivals. Okay, so minority shares, passive shares, less than 50%. Antitrust, however, has grave concerns about these types of arrangements, particularly given the incentives that it creates to compete less aggressively, because you have common ownership or you have common interests in other firms. So there's been a lot of empirical research done, actually on both sides of this question, which supports the notion of harms from common ownership, but also research that might critique that or to cast some doubt on that. So we have a vibrant body of research emerging in this area on common ownership, and there is certainly concern at the legislative level in Congress about these types of these antitrust issues. The enforcement agencies are very aware of these problems, and in fact have devoted resources to, for example, at the FTC hearings, in exploring the issue. It has popped up in some legislative proposals. So things are moving along. We just haven't seen one of our federal agencies bring a case involving horizontal shareholding, but I don't think the story is over yet.
So my final question links to my current interest in antitrust. I recently had an article published in the Harvard College Law Review titled "Reigning in the Digital Revolution, in Antitrust We Trust." And at the end I talked about very much this policy, almost policy of appeasement that a lot of big tech companies are pursuing now, whereby they are receiving a backlash from the European Commission and other bodies, the UK Parliament, and they've started to almost appear more conforming to the agenda. And I was wondering what the future of antitrust will look like for these firms, and how abiding you think they will be in the long run to new antitrust legislation being put forward.
Okay, so I think just by way of introducing facts, if you look at just in merger control in the United States, if you go back about 20 years and you look at the number of acquisitions that have been made by the tech firms, the big techs, what we find is that very few acquisitions have been challenged. So the average rate across all industries, across both the FTC and the DOJ, is about 2.5% of deals are challenged by the agencies. In the tech space, that is a much lower percentage. So there are concerns about the growth of the techs, the dominance of the techs, possible exclusionary conduct, buying up smaller rivals, mergers flying through like Waze and Instagram, and a lot of different acquisitions of smaller competitors. I think right now antitrust is struggling with how to apply our basic concepts to the techs. Big debate about whether the current standard, the consumer welfare standard, the current set of tools is adequate. Our view is it is absolutely adequate. We don't need to rewrite the antitrust laws. We definitely need to update them, to clarify them, to make it more clear that they apply in all of these areas. But I think the tools are there. The problem is that we've had such lax enforcement over the last 30 years that, and very few monopolization cases, as I was saying earlier, that a lot of the debate now circulates around, well, the laws must be broken. Because we haven't had enforcement, it's because the laws are broken, because the judges are not coming to outcomes that would, on the plaintiff's side, where they would protect and promote competition. So I think what the techs have done is they see these problems, they see the concerns about competition, and they are being more proactive now about proposing self-regulation, proposing different policy tools. My closing thought on, and that's good, my closing thought on this, though, is we shouldn't assume that antitrust is the fix-all for the problems in the tech space. Privacy, for example, is an enormous issue and does have a competition component. For example, there may be less incentives to keep consumer data safe if a company owns large caches of data or data processing capability. But fundamental privacy issues are almost a social regulation problem, much like in Europe, where they implemented a protocol to protect basic levels of consumer privacy. That's not an antitrust problem. That's very much a social regulation problem. So in the US, we have to unpack the concerns with the text into the appropriate policy tools. Social regulation, possibly. There are certainly antitrust issues associated with consolidation and exclusion. But there has been a tendency to assume that all of the problems with the text can be fixed with antitrust law, and I don't think that's true. They are a very large, complex problem and will require multiple policy tools.
Thank you. Thank you for agreeing to do this interview. It's been a pleasure speaking with you.
Thank you.
I hope you enjoy the rest of your time in Cambridge.
I'm already enjoying myself, so I hope for more.